Hello and welcome to Triage, rapid legal lessons for busy healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
Hello and welcome to Triage. My name is Adam Cooper. I'm an attorney with K&L Gates' Healthcare Practice Group out of Dallas, Texas. My practice focuses on healthcare regulatory compliance and litigation. Today we're going to talk about a relatively recent Supreme Court decision, Azar v. Allina Health Services, and a related CMS memorandum that addressed notice and comment requirements for certain types of guidance issued by CMS. In a memo from the Office of the General Counsel to the Deputy Administrator and Director of the Center for Medicare, CMS's legal counsel outlined the implications of the Allina opinion and the potential limitations on CMS's ability to bring enforcement actions if such guidance is not promulgated through required notice and comment rulemaking. In short, if sub-regulatory guidance impacts a substantive legal standard and proper notice and comment rulemaking procedures are not observed, said guidance cannot be used in subsequent enforcement actions. The Allina memo succinctly summarized the Supreme Court's holding when it said, any Medicare issuance that establishes or changes a substantive legal standard governing the scope of benefits, payment for services, eligibility of individuals to receive benefits, or eligibility of individuals, entities, or organizations to furnish services must go through notice and comment rulemaking. Of particular concern to the General Counsel is the Center for Medicare's promulgation of payment rules, as they often form the basis for enforcement actions. However, it's worth noting the Supreme Court's holding in Allina applies more broadly than just payment rules. Regardless, the General Counsel stresses the importance that the Center for Medicare conform the issuance of its guidance to the notice and comment requirements articulated in Allina. The General Counsel further explained the consequences of failing to comply with required notice and comment procedures when issuing guidance, stating, where the Department of Health and Human Services, or CMS, issued guidance that under Allina should have been promulgated through notice and comment rulemaking, the Department's ability to bring enforcement actions predicated on violations of those payment policies is restricted. The critical distinction is what specific types of guidance Allina requires to be promulgated through notice and comment rulemaking, or, as stated in Allina, guidance that establishes or changes a substantive legal standard. There are various non-regulatory CMS publications which often form the basis of enforcement actions, including, without limitation, Medicare's Internet-only manuals and the preamble text published with final rules. The General Counsel provides some instruction as to what types of guidance establish or change a substantive legal standard, and thus require the observation of notice and comment rulemaking. The General Counsel stated that guidance that is closely tied to statutory or regulatory requirements generally do not establish a substantive legal standard. Because these types of guidance do not require notice and comment rulemaking, enforcement actions implicating these guidance materials may still be brought. The General Counsel further explained that sub-regulatory guidance in these circumstances is not establishing or changing a substantive legal standard, but rather is aiding or demonstrating that the standard in the relevant statutory and regulatory requirements have been or have not been satisfied. Alternatively, guidance that is not closely tied to statutory or regulatory standards and is issued without the requisite notice and comment period cannot be relied upon in actions to enforce the standards articulated in that guidance as it was not validly issued. The critical question is whether the enforcement action could be brought in the absence of the guidance document. If the answer is no, then the guidance document establishes a norm and under Allina is invalid unless issued through notice and comment rulemaking. The General Counsel notes that the holding in Allina does not preclude CMS or the Center for Medicare from enforcing invalid guidance documents in its contracts so long as these guidance documents are specifically referenced in those contracts. Lastly, the General Counsel indicated Allina does not require local coverage determinations, or LCDs, to be promulgated using notice and comment rulemaking, but also stated government enforcement actions based solely on LCDs are generally unsupportable. The holding in Allina and CMS's subsequent interpretation affords providers and suppliers enrolled in federal healthcare programs a new argument to fight enforcement actions when those actions are based on sub-regulatory guidance that both establishes or changes a substantive legal standard and was not promulgated through notice and comment rulemaking. Analysis as to whether CMS guidance requires notice and comment rulemaking procedures will be a case-by-case inquiry, and we have limited examples of how these new standards might be applied. For example, in a recent administrative law judge decision, the ALJ considered the reimbursement for claims provided by a locum tenens physician. The ALJ considered two requirements related to the submission of the claims, one statutory and one found in the Medicare Claims Processing Manual. The statute required a locum tenens physician to include his or her MPI on the claim. The Medicare Claims Processing Manual required the procedure code to be followed by the Q6 modifier. There was no dispute that the locum tenens physician's MPI was not included on the claim. However, the ALJ acknowledged, in light of the Supreme Court's recent decision in Allina, it is unclear what effect, if any, I should give the Medicare Claims Processing Manual's requirement to use the Q6 modifier. Thus, the ALJ was able to reach the merits of the issue without fully addressing Allina's impact on the Medicare Claims Processing Manual modifier requirement, which was implemented without notice and comment rulemaking procedures. In conclusion, providers and suppliers dealing with government enforcement actions should examine, with the assistance of counsel, the authority on which that enforcement action is based to determine if that authority was validly promulgated. And that's all the time we have today. Thanks for listening to this episode of Triage.
Thanks again for listening to Triage, rapid legal lessons for busy healthcare professionals. New episodes are available for download through iTunes, Google Play, and other podcast applications. By subscribing to Triage, you will receive timely notifications of each new episode. Also, if you have any topics that you would like to hear discussed on Triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.